The coloniality of civilized nations under international law, a Westphalian legacy. This is another subchapter. The legacy of the Peace of Westphalia was not limited to the creation of nation-states, but also extended to universalization of the Westphalian or European experience through the instrumentality of international law, using the standard of civilization as a legal benchmark to judge societies. This is evident from Articles 9 and 38(1) of the Statute of the International Court of Justice, which was established in 1945, that is almost 3 centuries after the Peace of Westphalia. The said provisions read as under Article 9. At every election, the electors shall bear in mind not only that the persons to be elected should individually possess the qualifications required, but also that in the body as a whole, the representation of the main forms of civilization and of the principal legal systems of the world should be assured. Article 38(1). The court, whose function is to decide, in accordance with international law, such disputes as are submitted to it, shall apply a. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom, as evidence of a general practice accepted as law. C. The general principles of law recognized by civilized nations. D. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations as subsidiary means for the determination of rules of law. 2. This provision shall not prejudice. This was up till now we were discussing Article 38(1) and now we are in Article 38(2). This provision shall not prejudice the power of the court to decide a case ex aequo et bono if the parties agree thereto. While Article 9 uses the words main forms of civilization, Article 38(1)(c) uses the term civilized nations. Given that these terms have been used in the context of an international legal instrument that applies to an international court set up under the aegis of the United Nations, these terms must be attributed specific meanings and cannot be used or interpreted loosely. Article 38 has been typically understood as enumerating the sources of international law. However, scholars agree that these sources themselves are the product of Western civilization. In fact, they believe that international law is a living artifact of the Western civilization, or more specifically, the Westphalian civilization, since this political-theological framework of civilization was universalized through its imposition on the rest of the world by Europe and the United States under the garb of international law. Therefore, it can be reasonably contended that international law itself is a denouncement as well as a tool of coloniality, since colonies were faced with no other option but to adopt Eurocentric Western ideas, norms, and institutions. Scholars agree that the sources alluded to in Article 38(1) were the result of the application of the standard of civilization, quote-unquote standard of civilization, or SOC, by the West to bestow upon societies the status of civilized nations which were expected to observe and abide the rules laid down as international law. Importantly, the more practical and less lofty reason for the growth of international law was Europe's need to transact with non-European societies, wherein the standard of civilization was employed as an organizing principle. It ensured that business was conducted within a Eurocentric framework in order to protect the citizens of the West and Western ideas of universal rights and freedoms. Those that agreed to comply with the framework by recognizing the said rights and freedoms were deemed worthy of being accorded the status of civilized nations. Interestingly, the expectation was not limited to the application of the SOC framework, the Standard of Civilization framework, to Westerners in the non-West. Instead, non-Western societies were expected to reorder themselves on the same lines as European Westphalian states, which meant that the change was not merely external but also deeply internal to the non-West. The following were some of the specific changes expected of the non-West by the West. 1. Those rights and freedoms that were guaranteed to citizens of the West in their nation-states were expected to be recognized and available to them in the non-West. Non-Western societies were Number 2. Non-Western societies were expected to adopt the same forms of government as the West, so as to protect the freedoms and property of Western nationals within their territories. This effectively meant the gradual universalization of the idea of a constitutional form of government with three identified organs, namely the legislature, the executive, and the judiciary, whose metes and bounds were determined by the doctrine of separation of powers. The theoretical foundations of the same were provided by the Enlightenment thinkers such as Baron de Montesquieu and John Locke in the 18th century. As part of this expectation, codification of laws, which would be administered by courts set up on the same lines as courts in the West, was deemed mandatory so as to protect the property rights of Western nationals. This had the Lockean influence written all over it. Number 3. Non-Western societies were expected to reorganize themselves in a manner beneficial to the individual freedoms of Western nationals, although such nationals were immune to the application of domestic civil and criminal laws, being answerable exclusively to the consulates of Western governments. The basis for this position was distinctly supremacist and racist, that is, non-Western nations were not civilized and therefore Western nationals could not be subjected to the uncivilized political and legal systems of the non-West. Number 4. Non-Western societies were expected to have the capacity to defend their borders and territories against external aggression, apart from subscribing to the Westphalian model of international diplomacy and state sovereignty, which included non-interference in the domestic affairs of other nation-states. And 5. Not only were non-Western societies expected to abide by the principles of international law and become nation-states that subscribe to the rule of law, with regard to Western nationals, they were also expected to conform domestically to the norms, mores, and mores and customs recognized in and by Western societies. Effectively, European imperial powers gained extraterritorial jurisdiction over non-Western societies through application of international law, which was nothing but the enforcement of Protestant Reformation-inspired Westphalian principles. In the third section of this book, which relates to Bharat's constitutional journey, this subject is addressed in greater detail to demonstrate the application of the SOC, the Standard of Civilization, as a legal requirement for membership to international bodies, such as the League of Nations. The point being made is that harmonization of both economic and legal systems as a consequence of the application of international law, that is, internationalized European or Western law, was inevitable. To anyone who follows contemporary discussions surrounding international trade relations or human rights, it must be fairly evident that the situation has not changed. If anything, post-decolonization, the normalization of European coloniality through the use of international law has only been further entrenched, owing to the economic dependency of former colonies on the West. To digress a bit, it is important to remember that in the middle of the 20th century, when several colonized societies attained independence, the focus of the civilized world suddenly fell on the poverty of the Third World. It was conveniently forgotten that this impoverished situation of the Third World was a direct consequence of centuries of colonization. Instead, decolonization engendered a new talking point, namely that the new-formed nation-states must catch up with the West by focusing on development the European way. Viewed in this light, the impact of the economic aid extended by the erstwhile colonizers to Third World countries on the shaping of the discourse surrounding rights and development warrants deeper examination by experts from the perspective of entrenchment of coloniality using the economic needs of the former colonies as a bargaining tool. Coming back to the use of Standard of Civilization, it clearly served as a litmus test for civilization and international interactions, which led to the elimination of pluriversalism and civilizational diversity, only to be replaced by Western normative universalism and a liberal globalized Westphalian civilization. While on the one hand, the Westphalian system emphasized state sovereignty and non-interference in the domestic affairs of nation-states, it hypocritically interfered with the domestic affairs and the fundamental consciousness of non-Western societies. Simply put, the concept of state sovereignty was selectively applied to Christian European nation-states, while the rest of the world was fair game for undue interference. This completely eviscerates the claim of the Peace of Westphalia being a secular, liberal and egalitarian milestone that ushered in an era of respect among nations as equals. Members of the Christian civilization that subscribed to Westphalian principles were equals, but those outside of it, namely the non-Christian indigenous societies of the New World, were lesser and unevolved, who needed to be civilized and reformed through the instrumentality of international law. Scholars believe that the liberal globalized civilization is in fact merely a secularized version of the Westphalian civilization, whose secularization is largely attributed to the nature of the Enlightenment itself. Therefore, it is important to examine the Christian secular nature of the Enlightenment and its coloniality. On this subject, the work of Dr. S. N. Balagangadhara and Dr. Deruvar is incisive and critical.